In this video, I'm going to give you a brief look at the Washington State Constitution so we could see some of the protections it offers Washington citizens, which are above and beyond the protections offered by the United States Constitution to Americans in general. I will also share some of the problems that the Washington constitutional framers were concerned about 100 years after the framing of the United States, which is when Washington State was ratified, and how they addressed those problems at the time. We may find that we can address modern problems today in a similar fashion. And lastly, I'm going to show you why the language of the Washington State Constitution is incredibly relevant and practical today. You may be able to relate to this. In the 12 years that you spent in the public school system, which equates to about 15,000 hours of classroom time, you learned very little of what you would consider practical or applicable to real life. Even if you were lucky to have some sort of civics education, which I would assume that you got to be at least 50 years old to have, I never had any, chances are the scope of that education was very limited, and I would say chances are even better that you didn't learn anything at all about your state constitution. Now, I went searching for resources on the history of Washington, its government, and its politics. After enough digging, I was able to find some resources and articles on a University of Washington website that were exactly what I was looking for. What I found, quite honestly, blew my mind, and I want to share some of the things that I learned with my fellow Washingtonians and encourage everyone in other states to start digging into their own state constitutions to see if you might find something similar. So what did I find that was so interesting? What I found was that the Washington State framers were somewhat antagonistic and you could say even hostile to the concept of natural rights. Now, I understand this sounds really bad, and it also sounds very strange that an American state dedicated to the concept of freedom would say, hey, we have a problem with this thing called natural rights. Well, let me explain why that was the case and why there's something very important to learn from how the Washington State framers avoided the usage of natural rights and instead replaced it with this concept of individual rights. Now, of course, in 1789, when the United States Constitution was being framed, natural rights was on the tip of everybody's tongue, really getting its momentum from philosophers like Spinoza and John Locke, and really crystallizing in the philosophy of Thomas Paine, who I have on the wall, who I will argue is the founding father of the United States. Not the Constitution, he was absent for that, but for the moral and principled aspect of the United States, it was him. The framers of the United States were very concerned about the powers of government and were continuously working into the whether it's the Declaration of Independence or the Constitution, saying Congress shall pass no law restricting the right of blank, shall not pass any law infringing on the right of blank. Nothing like that is in the Washington State Constitution. In fact, the Washington State Constitution really tried to avoid the uses of the word law when talking about rights. This is interesting. So why would this be the case? So in 1889, which is when Washington was ratified, the framers were very aware of abuses of rights, not just from government. So remember, this is 100 years after the fact of the United States Constitution, and we're like, this era is full speed ahead into the Industrial Revolution, where you start seeing these corporations and businesses acquire so much power that, particularly if they're in a frontier area like Washington State, which in 1879, which is the first time a constitution was attempted, there was approximately only 75,000 settlers here. These corporations could essentially act like governments, where they move in, they've got all the money, they got all the technology, and a bunch of sparsely populated, not united settlers couldn't really do much against the fact if this railroad wanted to build this here, or they wanted to control this section of land, or these mining companies wanted to issue their own currency to pay for work, for workers. I mean, if you don't have a job and you need something to do, what are you going to do against these guys? So the Washington framers looked at this, they were very aware of this issue of breaches of corporate power on top, and not to minimize the breaches of government power. They're very aware of that, but they said, okay, there's more than just government breaches of power and government infringement on rights. Private institutions can also infringe on rights, and that's a problem. And you can see this in the Washington State Constitution, for example, in Article 1, Section 24, which is essentially the Second Amendment of the Washington State Constitution. It says individuals have the right to bear arms. However, this should not be construed as giving individuals or corporations the right to organize, maintain, or employ private armies. Now, I remember when I first read that, I laughed, because I knew the only reason that would be in there is if it was a problem at the time. And lo and behold, there was two very famous examples leading, right before the state was framed, of mining companies who had hired armed guards to quell striking miners. Another example is Article 2, Section 38, which is this. When you read it today, this seems very strange, but it forbids railroad companies from offering free transportation to public officers. Now, why would something like that be so important that they had to write it into the Constitution? And if you think about it, if you've got this very sparsely populated area, and these railroad companies come in, and the only modern form of transportation is railroads, if you can control pricing and say, okay, for you I'm going to charge $1,000 a ticket, and for you I'm going to give you a free ride, because you're politician A and you're politician B, and I don't like politician A, but I do like politician B, I can control who gets to go where, which is essentially I get to control what those people are going to do, which is obviously a massive overreach of corporate power. Now, in what some would call a strange twist of fate, and what I would call historically predictable, having read Carroll Quigley's Evolution of Civilizations, in 1889, the American populace in general was repeatedly finding their natural rights being trodden on in the name of natural rights. How does that make any sense? It makes sense through one of the sacred tenets of natural rights, which is the contract, that two free persons or two free organizations, or a person in an organization, are free to enter into whatever kind of contract they want to, as long as it doesn't infringe on the rights of somebody else. So this is great philosophy until one of those parties in the contract runs into a situation where they're so desperate that they'll literally do anything to get into that contract. For example, let's say I desperately need a job, and the employer says, okay, before I give you this job, you need to waive your right to sue me in case you get injured on the job. Well, if I'm doing incredibly dangerous work, that's a hard call to say that I'm living as a free human being, if that is the agreement that I've had to enter into in order to sustain myself. So one of the things that the Washington framers did is they explicitly added into the Washington State Constitution that the legislature was allowed to create laws to protect and create safety requirements for industrial workers. Now, leaving aside what that has turned into modern day with labor and industries, this was important at the time, again, 1889, because legislation that was being attempted like this, creating safety requirements in states back east, were constantly getting thrown out of court because they violate the judicial ruling was that this violated the right of contract between the employee and the employer. Now, if this challenge to the sacred right of contract is hard to swallow and conceptualize, especially to anyone with a libertarian background, I totally understand. We're really hitting a rift here where things get tense when we're talking about natural rights and how to produce a free society. Now, I want to emphasize this because I've changed my mind recently on this, and it's really important to point this out because I've garnered this from historical research, is that outside of outright conquest in war, the main method of acquiring slaves for an individual or for a specific culture throughout human history and across all cultures was to get a person into a desperate situation that they would agree to terms that would eventually lead them to a debt that they could never repay, thus becoming indentured servants at best or slaves at worst. Now, clearly that concept or that situation is repugnant to the idea of freedom, and clearly would be a concern to a worker in 1889 industrial America, where, you know, you're looking at the situation where I could either starve by not getting a job or go to work and die in this incredibly dangerous factory. Clearly conditions could be better than that. So the Washington State framers were really wrestling with these conflicting ideas, because I really don't want to suggest that they were just throwing natural rights out the window saying we got to protect people from corporations, because they were also incredibly concerned about chasing those corporations away. They said we need business here. It's really important that business wants to come here and develop the state and encourage people to move here. So the agreement that they reached, and this is fascinating, is that they forwent the language of natural rights and instead replaced it with individual rights in attempt to eliminate this issue of corporations using the concept of natural rights, and particularly the tenet of the sacred right of contract, to abuse the rights of individuals. And in enshrining the protections of those individual rights, the Washington State Constitution almost never mentions just whom these rights are being protected against. So as I said about the American Constitution, where typically the language is, Congress shall pass no law abridging the freedom of speech or, abridging the right to bear arms. In the Washington State Constitution, it says the right to bear arms shall not be infringed. I'm paraphrasing, I don't have it in front of my face. The right to free speech shall not be impaired. It never says from who, and this is on purpose, because the idea that the Washington State framers had is they said, we don't care who is infringing the rights, whether it's government or private, it's not allowed. It's unconstitutional. So, what are the ramifications of this? I'm going to argue that the ramifications are that this language, this hair splitting between natural and individual rights, is very relevant to the situation today. As we've seen, the king, formerly known as Governor Jay Inslee, has been going on a business killing spree with his lockdowns and mask mandates and these phases that keep sliding back and forth, where none of these rules make any sense, and all that he seems to be doing is leaving this body trail of businesses in his wake. What he's doing is he's getting around the constitutionality issue of his mandates by getting labor and industries to threaten private business to enforce his stuff for him. This is as clever as it is evil, and here's why. Because when the state goes after the populace in the United States, we tend to go all 1776 and get our feathers bristled and say, oh, you're infringing on my rights, which is good. That's what we're supposed to do. However, if a private business does it, we tend to fall back on this natural rights conundrum that I've brought up, where we say, okay, well, there's this sacred contract, and the private business is allowed to do whatever they want because they're a private business, right? So if I go in and I say, hey, I'm not going to wear a mask because it's my constitutional right that I don't have to put something on my face, it's a right of expression, it's a right of speech, it's a right of whatever, the business can say, that's great. I don't care about any of that. I personally don't want you here. You're trespassing. Get out. Now, that's what the right of the business is, right? They're allowed to do that. Or are they? That's the question I want to bring up. Or are they? This is where I want to reinvigorate the discussion that our state framers had in Olympia on July 4th, 1889. The Washington State Constitution protects individual rights from both government and private institutions. And even the king, Jay Inslee, said on the eve of his first proclamation of mask mandate in Yakima, if you haven't seen this video, go watch it, he openly states, hey, the reason I'm not wearing a mask is because I have a First Amendment right not to do so. Now, if the First Amendment is relevant here, or Article 1, Section 5 for the Washington State equivalent of freedom of speech, do private institutions in Washington State truly have the authority to force us to do things such as wear a shame mask or stay 6 feet away from everybody else, or, you got to go down this aisle this way and you got to go down the other aisle that way, just so we can engage in day-to-day lawful business such as grocery shopping or going out to eat? I don't think so, and I don't think the Washington framers thought so either. I'm saying it's time we've had another discussion on individual rights as the Washington State framers conceptualized them that we have as citizens in Washington State. Do the governor and the state as a whole have the authority to limit our freedom to not cover our faces in shame when we go out in public? No. Do the governor and law enforcement have the authority to jail and fine individuals for engaging in their freedom of assembly for things like weddings or funerals or barbecues? No. Do the governor and labor and industries have the authority to fine businesses for not infringing on citizens' individual rights? No. Do the governor and labor and industries have the authority to destroy businesses and therefore the livelihoods of those who work at said business and service those businesses when they do not comply with lockdown, mask, or phase orders? No. Do private businesses have the authority to tell citizens how close we can stand to each other? No. Do private businesses have the authority to deny public access to goods and services for expressing their individual right not to cover their faces in shame? No. By the way, a small bonus fact at the end of this video. Did you know that there is a civil rights complaint hotline on the Labor and Industries website? 1-855-682-0778. After watching this video, if you might have a clearer method of enunciating how your civil rights have been impaired, infringed, or abridged as of, the last 4 months or so, I would say feel free to give this public service a call and let them know.